All right, this is case number 21-172946. This is LBNB Funding LLC versus Andre Davis. Now, the matter is before the court. Looks like on a pending motion for summary disposition. Your appearance at this time, please.
Craig Fay, P81401 on behalf of plaintiff.
All right, thank you, counsel. And I'm looking for Andre Davis or someone representing Mr. Andre Davis. If you're on this Zoom, say something at this time.
Yes, Andre Davis checking in.
All right, thank you, Mr. Davis, and good morning to you, sir.
Good morning.
All right, the plaintiff in this matter, a motion for summary disposition, are asking that the court in this matter would decide on this case under the claim that there is no valid defense to the claim that they have brought, and that they're asking that the court will enter judgment on the basis of that position. Did you receive a copy of the motion for summary disposition, sir?
No, I didn't.
All right, so it looks like I set this up. Looks like I sent the notice out on July, and counsel, you sent the document to Mr. Davis.
Yes, we would have sent them out the same day that we mailed it to the court.
All right, and that would have been on about the 6th of July, correct?
Yes, I believe that's what the proof of service indicates, July 6th.
And Mr. Davis, you live at the address on Wickham Street in Detroit?
Yeah, I was. I'm not at the address no more.
How long has it been since you moved from that address?
Probably the beginning of June or the end of May.
All right, sir. Now, the court sent out a notice to you to come to this hearing at that address. You received the notice?
Yeah, I received the notice. They sent my mail back to the sender. So I had to go pick up all the mail from the post office.
All right, sir. And so there should have been, I mean, you should have received this motion item. So I'm gonna have Mr. Faith to tell me about the nature of this motion, and let's see what you have to say in response to that. Let's try that. Let's go right ahead, Mr. Faith. Let me hear from you, sir.
Sure. So plaintiff in this matter is the assignee of an account that was formerly with Credit One Bank. Exhibit A is the chain of title, which verifies the ownership of the account at issue. This account was originally opened January 13th, 2013. The plaintiff indicates that the defendant had use of the account, failed to object to the statements that were sent on the account. The statements that are attached as Exhibit B, they do indicate that there was payments, purchases, interest, and/or fees that accrued on the account. The statements, they do demonstrate defendant's knowledge of the account, its the terms and the remaining balance. There was a last payment on the account on August 21st of 2019. So as such, plaintiff contends that defendant remains liable for the amount that's set forth in the complaint, which is $1,411.95, plus cost of the filing and motion of service fees. And we also would indicate, obviously, Mr. Davis indicated he didn't receive a copy of the motion. So obviously there was no response to it. So I mean, at this time, just plaintiff is looking for judgment in the amount that is set forth in the complaint plus cost of filing and service of the matter.
And again, the amount paid for is $1,411 plus the appropriate court costs, correct, sir?
Yeah, $1,411.95.
All right, gotcha. All right, and Mr. Davis, this account, based upon the motion, this account arises from some business that you allegedly had with Credit One Bank. You recall that, sir?
Yes.
All right. So they sold the debt or transferred the debt to LBND Funding.
Okay, that's the problem. I didn't know who that was. That's why I thought I'd never had no contract with them, because I never knew who LVNV Funding was. I only knew about that.
I see.
So that was the confusing part for me. I never knew who company this was.
Okay, yeah, that's and I'm looking at the bill of sale where, you know, just like with with selling cars or homes or what have you, debt is sold as well. And so
Oh,
what Credit One did is they sold the debt. They sold their debt to another agency that ultimately LVMB funding owns that debt. So you can't expect that Credit One will come after you because they don't own the debt anymore. They sold it to someone else.
okay,
So
I understand.
you don't have any ongoing obligation with them. It's been sold to someone else. And what the motion is saying is that they have paperwork here showing that you made a number of payments on this bill, and then at some point there was a last payment back in 2019. And so with interest and what was due at that time, it's come to like $1,411 and some change.
Mhm.
So are you? I don't think that you're really disputing that, or are you disputing the debt? What are you looking?
No, I'm
for?
not disputing that.
Okay.
I'm just not really working at this time, so it'll be hard for me to kind of make payments on it, or I'll be asking them, can they give me a payment arrangement or knock some of the costs down so maybe I can afford to pay it.
What I'm going to do is I'm going to put you and Mr. Fay in a breakout room for just a moment to see if you can do that and come up with some type of arrangement to get it paid. If not, you come back in and we'll figure something else out. But let me have the two of you talk and see if you can find a way to a conclusion in that regard. So when you get there, you're getting a notification from me now to go to a breakout room, sir. Just click
Okay.
in, and
Okay.
the two of you get to talk. All right.
Perfect.
I'll see you. The court now calls case number 22-177-828. This is Dr. EB initials versus Citizens Insurance Company of, I'll strike that, the Citizens Insurance Company is the plaintiff in this matter of the Midwest, I'm sorry. Matter is before the court, settling for a pretrial conference. Your appearance for the plaintiff in this matter, Michigan Pain Specialist Counsel.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff, Dr. Vericara.
All right, thank you, Ms. Clardy. And Vorakara is spelled Vorakara for the record. Your appearance for Citizens Insurance Company of the Midwest Council.
Good morning, Your Honor. Alexander Wilson, P number 85510 on behalf of defendant citizens.
All right, thank you, counsel, and good morning to you as well. I see that, of course, an answer has been filed, and then I see plaintiff's answer to defendant's set of affirmative defenses. So it looks like, well, how far have you gotten along with this? Looks like you may need some time for discovery. What's going on here? Somebody update.
Well, Your Honor, the court on our previous pre-trial set discovery to today's date. I have spoken with brother counsel. We've been going back and forth about how much time they need, whether it be 30 to 60 days. I'm okay with an adjournment if that is what brother counsel is seeking. I did present a demand to brother counsel to try to settle the case. It's for a relatively low amount. Whatever they would like to do, that's fine. I trying to resolve the case. I think they need an IME or something like that.
All right, counsel.
Yeah, Your Honor, that's mostly correct. Brother counsel, we just got the records today. So we need to review those. There's also an IME scheduled for August 12th with the underlying claimant, and we actually just took his deposition yesterday. So we would just ask if we could have a little more time to get the transcript back from the deposition, review the records brother counsel just sent us, and hopefully get that IME report. And we should have this probably resolved within the next 60 days. So whatever the court could give us any more time, that would be great.
Sounds good. Sounds like I don't see where I said a a scheduling order or discovery order, anything along those lines. So it looks like you've been moving informally, because I don't see an order in the
Yeah,
file.
Your Honor, on the ROA, I didn't see an order myself. It just says on the ROA that discovery cutoff was today's date.
Yeah, I do see that now. Thank you. All right, so what I will do is I'm going to leave discovery open through the next action date. And I'm going to set that date out between 45 and 60 days hence, the date that the clerk's going to give me, and I'll give
October
that to you.
3rd.
I'm sorry.
October 3rd.
October 3rd will be the next action date. And that should give time for the MRI and the other assessments to be made. And of course, you gentlemen, if you resolve it in the interim, then that's all good and well. If not, you'll have that date to come back. That's going to be October 3rd at 9:45 p.m. October 3rd, 9:45 a.m. Another notice will be generated. And again, discovery remains open through that date. I also will indicate to you, and I will send out an order to that effect. My provision number 6 in the order provides that you may file motions in this matter to be heard on October the 2nd, so long as you provide and allow the other party at least 10 days notice before the hearing date. So you can file a dispositive motion or any other issue you wish to raise and set it for hearing on October the 2nd.
October 3rd.
Yeah, October 3rd. I keep changing. Thank you, clerk. It's October 3rd, everybody. All right.
Okay.
I say second, ignore that. It's October 3rd. Clerk has spoken. October 3rd, 9:45 a.m. But you can set your motion for hearing on that date, notwithstanding the typical court rules. All you need to do is make sure that the other party has at least 10 days prior to the hearing to respond to your motion. And I will hear it on October 3rd at 9:45 a.m. So good day to the two of you. And you'll get a copy of that order from me in the mail in the next few days.
Thank you, Your Honor.
Great. Thank you, Your Honor.
Good day to you.
Hey, Connor, I'll send all that stuff you sent me over to Lauren, and I'm sure she'll reach out.
Thank you. I believe I CC'd her too.
Okay.
Yeah.
Okay. Sounds good.
Thank you, sir.
All right, the court calls case number 12-100-032. This is Midland Funding versus, I think it's Shave Smith. The matter is before the court, set on for a review. All right, your appearance for the plaintiff in this matter.
Good morning, Your Honor. Brian Truba appearing on behalf of the plaintiff Midland Funding. My P number 61752.
Thank you, counsel. Good morning to you. I see that this apparently previously there was an objection to a writ of garnishment, and then I do have the defendant's response, right? That plaintiff's response to defendant's objection to garnishment. I set it over for review on today's date. Counsel, update me if you will.
That's correct, Judge. Last time we were here was June 8th. It was defendant's objection to garnishment. Because there was a valid judgment in the file, the court rightfully denied that objection, but asked us to send the defendant affidavit of identity theft. Looks like we did that on June 9th, and I had my staff send, there should be a proof of service of that in the court file. I know it's normally not necessary, but I just wanted the court to know that we did it. We have not received that back. And just so the court's aware, we sent it to the same address the defendant used on her objection to garnishment. So that's where we stand, Your Honor.
All right, very well. So again, I believe that would, at this point, conclude matters with this court, in as much as the court did find that the objections to the writ of garn were invalid. My order released funds to the plaintiff regarding this matter. And thank you for the update, counsel. Thank you for following the direction the court gave in regard to this matter.
No problem, Your Honor. Thank you. Have a good morning.
Good morning to you, sir. All right, we're back on the record regarding LBMB funding, LLC versus Andre Davis. I sent the parties out to have a discussion regarding resolving the matter. The subject is 2946. Mr. Fay, if you will update me at this time, sir.
Yeah, so I discussed with Mr. Davis and we able to come to a resolution via consent judgment. I explained to Ms. Davis if potentially we could put it on the record and either have the matter submitted under the 7-day or faxed or emailed to the court, however the court would like.
All right, if you will put it on the record and then simply, if there's agreement, then you can email it over to me and the court will get it signed up and parties could move forward accordingly. Go ahead, Counsel.
Perfect. So Mr. Davis indicated that he would agree to a consent judgment and we would resolve the matter as a settlement of $1,060. And that would be payable at $44 per month. And then payments would begin August 28th of this year and continue on 28th of each month.
All right, is that your agreement regarding this matter, Mr. Davis?
Yes, it is.
All right, the court will find that the matter is in fact settled then, and I will sign the order of funds presented. Mr. Fay is going to send that over to the court. And this, of course, so long as it has the details that you guys agree to, I'm going to sign it. And then Mr. Davis, you'll get a copy of it and you'll govern yourselves accordingly. And that should close this matter out. So
Okay, thank you.
thank you.
Perfect, Your Honor. Have a good day.
All right, good day to you.
Bye.
Short and sweet.